Good afternoon, everyone. My name is Natalie Winters. I am the Executive Director of the Competitions Program here at Berkeley Law. I'm so excited to introduce you to the final round of this year's 2025 1L Halloum negotiation competition. You can see the 4 finalists seated in front of you right now. They are about to start a live negotiation in about 30 seconds once I stop talking. I want to just briefly acknowledge that you can find the names of today's students finalists, as well as our donor firms and our wonderful volunteer judges who've taken the time to be here today. I just want to extend a special thank you to our donor firms and our final round judges, really all judges for this tournament, without whom this would absolutely not be possible as an educational experience for our students. Again, you can find their names, including biographies from our final round judges, in your program. In just a moment, you're going to see these 2 teams negotiate for a total of 40 minutes. During that negotiation, each side has the option to call a short break. So if you see that happen, don't panic. Please stay and wait till the end of the round. That usually only lasts 2 or 3 minutes or so. They do have the option to call up to a 5-minute break if they want. Clock doesn't stop for the break, though, so that's a strategic decision. At the end of the round, each side is going to have the opportunity to explain to the judges, as part of a post-negotiation analysis, how they think things went, what they might have done differently, what they thought was successful. After that, we will collect ballots from our judges, review the scores, and plan to announce a winner in front of you today, shortly after the judges' feedback concludes. We do plan to wrap up this event promptly at 2 p.m. I know many of you are students that have classes that are going to be starting in a couple of minutes, or maybe you've got a plane that you're trying to catch on your way off to spring break. Either way, we're very happy to have you with us here today. In a few final moments, we're going to get this negotiation started. Thank you again for being here.
Well, we'd love to start off today just by setting a brief agenda. So we were hoping to discuss some quick opening statements from both of our teams. Then we wanted to discuss the acquisition more generally, as well as what PlatFire's intentions are for the future of FoodieLove. And then we wanted to go into some of the specifics of the acquisition, the go shop provision, the termination and reverse termination fees, stock options, and a non-solicitation provision. Curious what you all think of this order, if there's anything you'd like to change. We'd love to hear from you.
I think the only change that we would make is that we'd like to discuss the termination fee at the end. We think, from our perspective, the likelihood that there would be a termination is low, and so we just think that in terms of the priority for conversation, that would be lower. But we're in alignment in terms of go shop initially, and then the stock options, as well as the non-solicitation next.
Okay, that's no problem for us. We'll move the termination fees down to the end. But why don't we just get started then? So our goal today is ideally to work out the specifics of PlatFire's acquisition of FoodieLove in a way that ideally suits both of our clients. Our client Sarah created FoodieLove as a way to bring people together and make impactful connections, and it has now grown to be a public company. A high priority for us today is understanding how this acquisition will impact the experience and safety of FoodieLove's users. We're super impressed by PlatFire's growth and believe your client's capabilities work well with our client's desire to make the app safer for everyone. As we begin to look towards the future of the app, we'd love to pass it over to you to understand what your goals are for today.
Sure. To begin with, I think we can both appreciate how far FoodieLove has come in maturing to being a small private company from a product that started here at this campus to something that we would hope to help further mature and produce into one that happens to be secure at the very heart of it. Our value add at the core of it is ensuring that FoodieLove continues to add value to the market by being the most secure option of the apps available on the market. Mitchell?
Yeah, our client is just really excited about how many synergies there are between 2 ostensibly pretty different companies, and especially with the government contracts and the technology that FoodieLove has to offer, we're really excited about the potential acquisition.
Yeah, we're super excited as well about the acquisition. We know you'd initially made an offer for the full acquisition of the application, including the dating, the gaming, and the facial recognition technology. And we were just hoping to understand a bit more about what your hopes were for each of those components. As you know, Sarah created this app from scratch, and the dating, the friendship, the gaming components of the application are really important to her. And we know you're a security company, and so we really think you could add value to the application. But we'd love if you could tell us a little bit more about what you were hoping to do with the dating and the gaming portion of the app.
I see. And for the dating and gaming, does that come from a concern that the client has?
Yeah, so given that Sarah, this app means a lot to Sarah, she just wants to ensure that this application continues to live out its mission. And so we were just hoping to understand a bit more about the dating and gaming components.
Yeah. So with full acquisition, the client has made no express statement about whether there would be any sort of deprioritization as to the dating and gaming. And so as the representatives of the client, we wouldn't be able to say whether they're going to be prioritized over the facial recognition technology or deprioritized. Mm-hmm. And the interest in acquisition, I think we're aligned in terms of continuing to grow FoodieLove as a company, even as a part of PlatFire. And that we'll probably speak a little bit more to when we talk about the stock options and non-solicitation as it relates to employee retention and employee morale.
At its core, we want to make sure we can maintain the integrity of the product as it is and simply add value to it given our competencies and seeing how we can grow it to a product that's even more mature and speaks to what seems to make the product resonate in the marketplace in the first place.
Yeah, absolutely. And thank you for kind of elaborating on that. I think we'd like to know a little bit more specifically about how you plan to use the facial recognition technology. I know you all have a plan to expand into new security-based markets with using this technology. And we know there's been some rumors circulating about potential other uses. So if you could tell us a little bit more about how you plan to use that technology.
From our perspective, our knowledge is that it will be used for the safes and the stated from the general information. We do not have additional information from the client.
No problem. I think just in order to build confidence for our client, and of course we'll go into the rest of the provisions here, and perhaps that would also build confidence, but in order to build just some confidence that the gaming and dating components of the application will not be immediately discarded, we wanted to know if your client would be open to signing some sort of agreement that would promise to keep those components of the application running for a set number of years. We understand if this isn't something you can agree to today, but we'd love for you to take this to your client. This is just going to be really critical for Sarah, given that this company, she's grown herself, and it's been successful. So.
While we have no express authority to engage in that kind of agreement, I think we can ensure alignment and make sure to at least come down to a deal that helps speak to those concerns, making sure that we can retain employees, ensure that continuity is established at the very least post-closing.
Thank you so much.
So we're moving forward with a full acquisition and some sort of promise that will go back for final approval by your client on some term of time to keep all functions of the app open and running. So that sounds great. With that, let's move on to Go Shop provision. So FoodieLove has a fiduciary duty under Delaware law to solicit other offers and just ensure that our shareholders are getting the best possible price. As you all know, online dating is one of the fastest growing markets, and we have a responsibility to our investors to continue to test that market and make sure we're getting them the best price we can. We're really excited about the prospect of closing a deal with you all today, but we will need some sort of Go Shop provision in place in order to move forward. With that in mind, we'd like to propose a 90-day timeline, of course, with matching rights that would guarantee you all the right of first refusal if any other offers pop up.
Could we understand a little bit more as to why the 90 days and why 3 months is required to fulfill the fiduciary duty?
Yeah, for sure. As I mentioned, the market fluctuates, and we want to just make sure that we have enough time, realistically, to solicit a full offer from someone else. We recognize this is a bit above an industry standard, so we have some room to be flexible here. But it's really just important to do our due diligence. We have this duty under Delaware law, and we just want to do the best we can on behalf of our shareholders.
I think we agree on the very need to have at least some time to gauge the market. At the same time, considering that, I think we also want to be mindful of time and resources in getting the deal done, and would rather avoid or would like to avoid having ambiguous deadlines and processes that are a little too stretched out for what might be best for getting this deal done. So I think as a starting point, and of course we can work some finer details out, 30 days is what we were hoping for when it comes to time to solicit offers.
Right. And to clarify, the 30 days, that would be without the matching rate.
30 days without matching rights. I just want, okay. Okay, really appreciate you sharing that. Perhaps we can move on to something else and come back. I think we could probably come to an agreement there. For us, 30 days is going to be a little bit short just because given the fluctuations of the dating market, it is a market that moves very quickly. We are not sure that 30 days is going to be enough time to test the market. But for now, we can move on if that sounds good to you all.
Sure.
Okay. So moving on to stock options. Obviously, this is going to be heavily tied to what the composition of your employees are going to look like. So we were wondering if you all see yourself bringing in a new team, or are you more so interested in incentivizing the current employees to stay on and continue their work at FoodieLove?
We would rather have employees stay on and continue work as a part of PlatFire. And with that said, our ideal would be a rollover to options to purchase PlatFire stock. At least in our view, this option would permit us to retain talent to work on the product as it is, and in conjunction with other perquisites that come from being a more mature company, I'm sure that employees would find that a satisfactory reward for their continued performance with the company post-closing.
I think what the good news here is that we're in alignment in the sense that I think by keeping on some of the employees here, you're more likely to also live out Sarah's vision of hoping to keep the company running for as long as possible. That being said, we definitely were hoping to, initially we were hoping to have PlatFire accelerate all of the invested options. That was before we heard that you wanted to have some of the employees roll over. So for us, I think it's going to be important to have some percentage of the unvested stock accelerated. And that's just to show some loyalty to our employees who have been there at the company since it started. They've worked really hard on this company, and we do feel it would be a sign of good faith from PlatFire as well to accelerate a percentage of those stock options and then have a percentage rollover as well to incentivize employees to stay on.
Yeah, I think that's fair. Yeah, we just want to make sure that whatever percent is accelerated is commensurate with the tenure that these employees have. And so we were wondering if you have any information as to the employee breakdown and how many years generally have the employees served on the company, or maybe even if there's more granular information as to the options themselves, how they're distributed in terms of years out from vesting.
We don't currently have a ton of information on that. That's definitely something that we can go back to our client and ask about and come up with some sort of creative solution there potentially. For now, I think that maybe the actual details of the stock options can be figured out a bit later. But for now, we'd love if we can come to some sort of agreement percentage-wise of percent that is rolled over and percent that's accelerated. Is that something you can do without that information, or would you like us to sort of just table this discussion for a later time?
I think it might be a decent idea to perhaps get some more terms out on the table. But we are more than open to considering creative ways in which we can combine acceleration with perhaps various triggers to see what we can do in getting something that combines some of our interests together in a meaningful way.
Okay, that sounds good then. Moving on to the non-solicitation provision then, we absolutely understand, especially now that we know that you're hoping to have a lot of the employees from FoodieLove come work at PlatFire. We know that it's important to have a non-solicitation provision in place, so I believe we'll be in agreement there. I do think that we were hoping to have some exclusions to the provision, but we were curious what you were thinking in terms of the non-solicitation provision.
Yeah, so I think generally, similar to the stock options with the non-solicitation, we're really prioritizing that the employees can stay with FoodieLove and continue to develop the product, especially with regards to these government contracts and implementing the tech into PlatFire's product such that these contracts can be successfully fulfilled. We're interested in having a non-solicitation provision that covers the engineers, project managers, the CFO, and the COO. And we were wondering from your perspective if you had any information regarding how long it would take to develop and implement that product and potentially even refine it after it goes into the market.
I'm sorry, could you clarify what product it is that you're talking about?
The facial recognition technology as it could be applied to PlatFire's security product.
I don't think we have much information on exactly how it would be applied. Our understanding is, I mean, we've been able to use it within the gaming app software, and there's been a lot of different uses for the facial recognition software. But in terms of actually how long it would take for us to develop something, I don't think it was our understanding that we would be developing something for PlatFire.
Yeah, we've had engineers working on this since the beginning of FoodieLove, and we're really excited specifically about working with PlatFire because we think that your team has great capabilities to take this technology to the next step and implement it more smoothly. So we don't have any specifics. We're happy to discuss with our client on timeline there. But in terms of the provision, did you guys have any sort of timeline in mind for how long you were hoping to have the non-solicitation provision in place?
As an initial standpoint, we were hoping for a 2-year provision across the classes we just mentioned.
And then in terms of the classes, I know you mentioned, you had mentioned a few people here. Would you mind repeating them again?
Sure, no worries. Engineers, project managers, the CFO, and the COO as well.
In terms of those people, could you just explain a little bit more about why those people are important to you? If there are any of those people who are more important to you than others, that would be helpful, I think, as well.
Sure. At the very core, I think the rationale that undergirds all this is one shared with our prior discussion of the stock options. We want to make sure that the core staff who were able to develop FoodieLove into what it is today are able to remain with PlatFire post-closing. And it would be, I believe, a great benefit to us if we could also maintain some of the same leadership to take greater advantage of existing trust and goodwill that's been built within the organization after closing. We'd rather not disrupt that if possible. So in our view, making sure that we can at least have some reassurance that this provision might be able to help us attain that end, I think would be tremendous.
Yeah, absolutely. I really appreciate you sharing that with us. I definitely think that we agree that some of the employees should be subject to the non-solicitation provision. In terms of exclusions, our reason for wanting to have some exclusions here today is that Sarah has developed really close relationships with some of these people. She started this company from the ground up. And so she's built a lot of trust in these relationships, so it would be a really big loss for her to walk away from these people completely forever. This is not to say that she has some kind of big plan in mind to start a new company with these people. There's no such thing in the works at the moment, but she has worked to develop these relationships and so would like to keep some of these people on board.
Could you give us a sense of what those exclusions might be?
So we were hoping to ideally have the COO excluded and the CFO excluded from the non-solicitation provision. And as a starting point for us, we were hoping to have a 6-month non-solicitation provision.
So for this 6-month provision, that would include only the CO and CFO?
Exclude the CO.
Excluding
Okay.
the
Can you
CO,
clarify
yeah.
there?
So the 6-month provision would be for all other employees, including the engineers and the product manager. But the COO and CFO would be completely excluded.
I see.
Okay. Now that we have some initial numbers up on the board, do we want to move on to termination fees?
Yeah, that works.
Okay.
All right, so we're just curious to know more about what you all had for termination, had in mind for termination fees, both the actual amounts themselves and the fee trigger. We think it might be easier to break this up into chunks for the negotiation. So if we want to start by just talking about the different percentage amounts and what you all had in mind there, and then we can move on to the fee trigger afterwards.
Sure. So initially at parity, 5.5% termination fee, and then an equal reverse termination fee payable upon notification of intent to enter into another offer.
Can we hear a little bit more about why you're interested in 5.5% specifically?
Sure, we think a reasonable estimate of potential damages that may come from that, and the timing as well would also be advantageous to both sides should, in what we hope to prevent, should that come to pass. I'm sure this would permit some foreseeability on your end as well, making sure that we have some figures set aside.
Okay, thank you for that offer. So for us, I think that we were hoping to have a bit of a higher reverse termination fee in comparison to the termination fee. And the reason for this is that we are here selling Sarah's entire company. So we feel that we're taking on a bit of a bigger risk. And we've also spent a lot of time and resources in preparing, of course, for this acquisition, as I'm sure you have as well. But given that it's the entire company, there are things that are in place that if the deal doesn't go through, we'd have to potentially rearrange certain teams and things like that. So we were hoping to have a higher reverse termination fee and a lower termination fee. So in terms of a reverse termination fee, we were looking at closer to 6%. And then in terms of the termination fee, we were hoping for closer to 2%.
Yeah, I think initial reaction for in terms of the termination and reverse, when taken together, our client actually is a little bit more concerned about the termination likelihood rather than reverse. And so we see that the termination percentage would ideally be higher. We think, I think one of the main concerns is where FoodieLove might be shopping for their offers. There were rumors of the potential InstaShare offer, so we were interested in hearing a little bit more about that.
Yep. Yeah, go ahead.
Yeah, so we have had some offers in the past, but making a deal with PlatFire is our goal today. And in terms of why we think we need a little bit higher of a fee on our end, obviously this is about the relative risks that both of us are taking, right? But we are personally a little bit concerned about recent public attention and some media articles that have come out regarding the implications of your company acquiring both the facial recognition software while dominating the surveillance and security market. You know, we're worried about any sort of potential backlash or regulatory attention that might bring to your business and your ability to ultimately keep FoodieLove up and running, as we discussed earlier.
Sure. Well, as an initial matter, we want to avoid any possibilities of catastrophizing here. I'm sure we can arrive to some sort of agreement that ensures we can adjust for those risks, but also while keeping in mind the fact that they're rather speculative at this point. All that has existed, as far as we know, is just a bit of speculation in the press, and we don't necessarily have any plans that would either threaten the integrity of the product, as it were, or perhaps cause further concern to the best of our knowledge.
Yeah, I appreciate you answering that. I think our client, her biggest concern is user safety and people feeling comfortable and safe on the app. So it's just, you know, our duty to do our responsibility to our client and clarify that point.
And I just wanted to clarify, based on what Mitchell said, it sounds like what your client is concerned with is ensuring that we don't walk away from the deal, which is why you're hoping to get a bit of a higher termination fee. Is that correct?
It's just assessing the likelihood of which party might be more likely to walk away from the deal. I think our client is a little bit more concerned about the termination circumstance. And so I think, quick question for this 2 and 6, that was upon notification, is that correct?
No, so we haven't spoken about the trigger yet for that. For us, in terms of the triggering, we would prefer to have the termination fee triggered upon the closing of another deal. And that's just to minimize risk on our end, again, because we've put a lot of resources into making this acquisition happen. What were you all thinking there?
Let's see. Well, at this point, we have at least an initial perspective from both sides across all 4 of the terms. Would you be okay with taking something like a 3-minute break?
That sounds good, Tess.
Okay. Yep. Here we go.
All right, we've got some terms on the table so far. There's about 10-ish minutes left in the negotiation. Please keep your seats until the remainder of the negotiation today out of respect for our judges and finalists that are here today. Our finalists will be back in just about 2 minutes to finish the negotiation. Thanks for your attention.
Okay. We're thinking we could put some offers on the board. Ideally, so we'll start with the go shop provision. We understand that you'd like to make sure that this deal's sort of accelerated a little bit more, so we're willing to come down to 65 days for the go shop provision, and that is, again, with matching rights. So we feel that that would ensure that you'll still have the first right of refusal. We are committed to working with PlatFire. That is our #1 goal today, so that's what we'd like to propose there.
Curious to hear your thoughts.
Yeah.
We do think 65 days is a little bit too lengthy for the reasons that we shared earlier, just with regards to the incentive to close the deal. And so we were thinking without matching rights, if 45 days would be okay. Let's get this one.
Okay. Is there a reason in particular that you're not interested in the matching rights, or are you sort of doing it as a measure of?
Mainly as a concession.
As a concession, okay. I think that we can move on for now to the next provision.
Sure.
So in terms of stock options, I know we hadn't really put out any numbers yet. We wanted to propose 80% of stock be accelerated, paid out, and then 20% rollover to employees. And again, this is just as ideally a sign of loyalty and good faith to the employees of FoodieLove who have been around for quite some time.
And you were hoping to have this be triggered upon closing?
This is for the stock options.
Indeed, acceleration triggered upon closing.
Yeah,
Okay.
I believe so.
Yes.
Sure.
Oh, upon closing this deal,
Yeah.
yes.
I think especially with our concerns that we mentioned before with regards to how much tenure there is with the employees right now, 80% seems a little bit large, especially when we take into account the possibility that there's going to be a lot of employees with options that have invested for multiple years. And also for tax efficiency purposes, having a large upswing in terms of the employee income would increase the payroll tax that the company has to pay. And so we were thinking something more like all the options which are 1 year out from vesting may be accelerated, capped at 40%.
Okay, that's definitely, it's an offer that we could consider, but I think that for us, we were really hoping to have a bit more accelerated. I think that this is something that maybe we should put the other things out on the board and then we can come back to as well. It may not be something we can agree upon today. We may have to take it back to our client. But why don't we move on then to the non-solicitation provision?
Mm-hmm. Yeah, I think for the non-solicitation provision, the engineers and the PMs are really critical, and we need them to stay in order to fully develop the product, especially for PlatFire's product. I know we were talking about how FoodieLove already has the facial recognition technology product developed, but our understanding is that it's not just a portable product. We would have to be able to adapt it so that it can work with PlatFire's product. And so we need to be able to keep them, and what we're thinking is that the engineers and PMs would have a non-solicitation provision applied to them for a year and a half, and the CFO and the CEO would only be included within that non-solicitation for 3 months, such that after closing, for the first 3 months at least, they can really set out the strategy across both FoodieLove and PlatFire's new workforce so that they can really develop this product and get into the market.
I think as we discussed earlier, we're definitely aligned on having some of the key engineers and product managers stay on for a duration of time to make sure that everything goes smoothly as you guys transition in through the acquisition. I think we had something in mind closer to a 9-month provision for the engineers and product managers. And then I know you guys also mentioned that you wanted to retain some key leadership as well. So we'd be prepared to offer a 6-month provision for our CFO, just so we can ensure that everything is clean with the financials as we're transitioning in and assure that the company stays afloat. And then our COO would be excluded from the provision.
Is there a reason why, like between the choice for the CFO rather than COO? I'm just curious.
Yeah, I think our client has just built really strong relationships over time. And like I mentioned before, the future stability is critical for her. She wants to see FoodieLove continue to grow and expand into other spaces. So I think having the CFO stay on would be the best way to ensure the financial stability of the company as you guys transition in.
I see.
Okay, so we can move on to the termination fee then. We understand that you wanted to be a little bit closer. So I think that we are prepared to increase our offer for the termination fee to be 3%. And then in terms of the reverse termination fee, we can come down to 5.5%. Go ahead.
Yeah, I just wanted to speak a little bit more about why we think this is reflective of the risks that each of us is taking. So we have no reason to believe that this deal won't go through with PlatFire. It's what we're very much looking forward to. But on the off chance that this deal doesn't go through, it also has a reputational risk for our company. It reflects poorly on us, and if for some reason this doesn't go through, it raises a red flag to any other potential acquirers that maybe our product isn't valued correctly. And again, we're worried about those privacy concerns, as speculative as they might be at this point. There's no telling what'll come a few months from now, and we just really want to ensure the financial stability and continued growth of FoodieLove.
And then I just wanted to mention that this would be still contingent upon closing. The trigger would be closing another deal.
Yeah, I think taking the trigger first, it's really essential for our client that it be at the latest upon signing another deal. With regards to closing, if the contract is terminated and FoodieLove eventually doesn't close on another deal that it signs, then the termination fee would not be collected based on that trigger. And so we think in order to kind of meet and really align our interests, having the trigger be upon signing, I can write that down. Might work a little better to both parties' interests. And taking that into account with regards to the termination in reverse, then for the reverse, we would be willing to go up based from the 5.5 such that it's 6.6% in the scenario that PlatFire is terminating, but we would still want a higher termination fee from FoodieLove given the concerns with potential other offers and shopping for different bids. And so we would want to see more like 4% from FoodieLove.
Understood. And I just want to reassure you again that the go shop period, really the main priority there is to make sure we're getting the fair value of the company. It's not so much that we're hoping to find another bidder. But appreciate you explaining your reasoning there. If we are willing to agree to the termination fee being triggered upon signing as opposed to closing, would you all be ready to accept a termination fee at 3% and a reverse termination fee at 5.5%?
No, I think with the signing trigger, we definitely would not be able to do the 3% in particular. I think with our client, that doesn't seem to reflect the potential for termination from FoodieLove's side. And so, yeah, with our offer, like with the signing trigger, what we proposed was the 4% termination with a 6 reverse.
Understood. Are you willing to have any flexibility in terms of that 4%, or is that a hard line for you all?
Maybe we can circle back on that, given that we haven't reached
Sure.
finality on the
Yeah.
first 3
and
terms.
what's our timing?
Just for awareness, we're at about
3
2.5
minutes?
minutes.
Okay,
Yeah.
no worries.
Perhaps in turn we could revisit the go shop provision. I believe there might be a bit of play available there. Perhaps if we say give you 55 days.
With the matching rights.
And perhaps in turn a 4% termination fee to account for the risk we'd be assuming by perhaps even risking a full-blown market auction at that rate.
So you're proposing 55 days with matching rights, and then a termination fee of 4%, and the reverse of 6% with signing. I think for us, this is already a bit of a concession for us. I think that we will need to then either have the trigger be upon closing, or we could have the trigger upon closing and offer you the termination fee at 4% and the reverse at 6%, or we could have it closed on signing and then 3% and 5.5%. Honestly, I think we could do 3.5%. 4% is a bit hard for us. So just to reiterate, it would be the termination fee at 3.5%, the reverse at 5.5% on signing, or the reverse with closing, and then 55 days with matching rights.
And we're at less than a minute left.
And the trigger again for non-termination?
The trigger would be signing if it were 3.5.
Okay, I think those 2 terms might be set.
Okay. Okay. And then in terms of the non-solicitation provision, what did you think of our offer? Is that something that you'd be willing to accept?
We wonder if we could we're okay with the CFO only, but we were wondering if for the engineers and PMs we can move up to 1 year where the CFO would then only have to stay for 3 months or have a non-solicitation provision applied for 3 months.
Would you be willing to exclude the COO if we agree to those terms?
Yeah.
Okay, I think we can do that. So it would be 1 year for the engineers and the PMs, and then a 9-month provision for the CFO.
Or just to be fair, it would be 3 since you're first.
Oh, I'm sorry, 3, yes. Thank you. And then the COO would be excluded.
Yeah.
Perfect, okay. So then we will negotiate the stock options at a later date.
More to come. Okay, so next next, we're going to have both teams head out into the hallway. Both teams, you have 3 minutes total to get ready for post-negotiation analysis. Audience, that's the part where they tell you what they think worked and why, or what they might have done differently. And those 3 minutes are starting now, teams, so you are on the clock. The first team that's going to do post-negotiation analysis will be FoodieLove. Again, please keep your seats until the end of today's event. We really appreciate you being here, and I'm sure the finalists will appreciate your attention until it concludes.
Go ahead.
Okay, first off, thank you all for being here today. We really appreciate your time. So going in, our overall strategy was to conceal any indication of the app's recent financial struggles, and instead we wanted to ground all of our reasoning and our offers in Sarah's dedication to expanding the app, the dating app and friend app space, and in making it a safer space for all users. Because a priority for our client was ensuring that the application and its components were not immediately discarded, we wanted to start the negotiations by asking questions to kind of determine PlatFire's intentions with the different components, and we were able to implement a creative solution to sign an agreement promising that none of those different components would be discarded. We knew it wouldn't be in the best interest of our client to move forward without it. So going through each provision, starting off with the Go Shop provision, we really wanted to kind of downplay this and frame it as, just a procedural step or a means to an end to closing our deal with PlatFire. But in fact, we knew this was actually a key provision for our client due to both a previous offer from InstaShare and pressure from investors. We also wanted to negotiate this with the termination fees in mind, as both of those heavily revolve around the level of risk that each entity is taking and the likelihood of terminating the deal, and we felt that we could maybe use one to leverage the other, and that is actually how it played out in real time. So we ended up at 55 days with matching rights there. Moving on to the termination and reverse termination fee, we were able to justify an uneven percentage between fees, without disclosing at all that our client is in a tough financial spot, and we relied on different privacy concerns, reputational risk, and the expenditure of resources to help move that deal forward. We ended up at 3.5% for a termination fee, reverse termination fee of 5.5%, and trigger upon signing another deal. We had a hard line for the termination fee at 4%, and we were able to move a little bit away from that, which is great. For treatment of stock options, unfortunately, we weren't able to come to an agreement here, but we were able to, start the discussion of some sort of percentage split between accelerating stocks and rolling over stocks. And finally, for non-solicitation, we wanted to conceal the fact that Sarah had, in fact, already promised the COO position to be excluded, and that the COO would be appointed at her next venture, and we were able to get the COO excluded under a term of a 1-year provision for all other employees and 3 months for the CFO. Throughout the competition, our strategy has been to just ask as many questions as possible and find out as much as we can from opposing counsel before we make any offers. We've got a lot of positive feedback from judges in past rounds because of this, and I think we did a great job of continuing this strategy today.
My bad. I also wanted to say that I think that we got a lot of feedback in previous rounds about rushing a lot at the end, and there was still a bit of a mad dash at the end, so that's definitely something we want to work on. But we also got feedback that it's better not to rush at the end and just save some things for later sometimes. So I was actually glad that we were able to sort of realize earlier on that the stock options weren't, we didn't have enough information to figure it out in the given moment. So I was glad we were able to save that for a later time. I think that the other team did a really excellent job at answering all of our questions and justifying everything. We really wanted to get more information out of them, and I think they did a really good job. They had their reasoning set really strong. And I think that we also did a good job of leveraging different points at the end, especially of coming down in some places, but not coming down too much in others, in order to get the most efficient deal for our client. We got the most important things done, which was, the promise has to be taken back to the client, but that was critical for our deal. Having the COO excluded was critical, and then not going above 4% for the termination fee was also critical for us. So,
and just to wrap up here in the interest of time, we've learned so much throughout this competition, and we've had a really great time learning each other's individual strengths and how we can leverage them and work together. So we're just really happy to be here, happy to have the chance, and thank you all.
thank you.
Oh.
You sped through it.
Sorry.
What do you think was the reason you weren't able to figure out the stock options piece?
Yeah. So I think I think part of it was they had come up with a creative solution, which I thought was a great solution, actually, and I'd hope that in the future, if this were to continue going, we could discuss it with them. But because we didn't have the facts and given the time frame to answer, for example, a 1-year option, then we just decided to deprioritize it just because we felt we wouldn't be able to get it done in the time frame, and we would have to take some information back to our client.
And just the way that it worked out with timing, we were coming up to that as we had less than a minute on the clock, and we had learned from previous rounds not to jump the gun and agree to something just because the clock is running out. And so it wouldn't be fair to our client if we did that mad dash and tried to put some number on the board rather than taking the time to really flesh it out and understand where the wiggle room is on both sides.
I noticed that oh yeah, go for it.
Thank you.
We'll come at the end.
Which way should we face? Do you have a preference to which way we face?
Sedentary.
Okay.
Sure.
Sure. First of all, thanks so much for your time in being a part of the judging panel. In terms of the negotiation, we wanted to start off with the general case presentation and how we felt. We felt that we had a strong understanding of the general as well as the confidential facts in terms of how we advocated for the client and the terms that they were seeking as a target versus what they were willing to concede. Although where we felt that we could have done better was kind of predicting what competing interests the opposing client might have and figuring out how to reconcile that. I think during discussion it was clear, especially with the termination fee, that our clients had reverse perspectives with regards to which scenario might be more likely, whether it's a termination or reverse termination. And being able to navigate that sort of pretty much exact opposite perspective between those clients would have made the conversation more fruitful in terms of negotiating that term in specific.
Sure. I think one thing that was perhaps valuable was the fact that we were able to get down a full sheet of competing terms on either side. And it would have been even more valuable had we had the time to actually seize on some of the interconnections between the competing terms to try and get a bit of movement on them beyond just squabbling over particular figures or numbers. And I think we got a bit of that, a taste of that, at the very end when we were able to get to at least some consensus on the go shop and termination provisions, which were both ultimately undergirded by the same concerns. Same goes for the stock options and non-solicitation options. Had we been able to perhaps spend a bit more time on those, perhaps there could have been some movement on, say, restrictive covenant had we gotten a bit of more favorable terms on stock options, or the converse might also have been true. I think that perhaps might be a bit of food for thought, considering a whole scope view of how things went today. But with all that said, glad that we were able to at least get some firm terms that approached what we were hoping for in terms of parameters we had. As thin as the facts may have been, I think the fact that we were able to reach a bit of consensus.
On the Go Shop, I was surprised that you gave up the matching rights so quickly as a counteroffer. I'm just curious what the thought process was there.
I think given that FoodieLove came in with the initial offer with the 90 days plus matching rights, to come in with our initial counteroffer with the 30 days without the matching, or with matching rights, would have seemed a little bit too contentious, especially early on in the conversation, and we didn't want to set the tone such that it would seem really unlikely that we're going to come to any agreement on the terms. And so we started with that, especially given our confidential facts didn't specify that the client wanted the 30 days with the matching rights, thinking that as we foreseeably would come to agreement, we could either get terms within our client's desires at a lower time period without the matching right, or something still even under the 60 days with that matching right, such that we could still advocate successfully for the client's interests. And to build off of what Vlad said. I think our initial perspective with the ordering of the terms, as you saw in the beginning of the conversation, was that those two middle terms, the stock options and the non-solicitation, really speak to the same general interest with regards to employee loyalty, employee morale, if there's a case of a potential huge lift out of the company. And we wanted to talk about termination last, mainly because from our facts, it was really based off of the terms that we would get in the first three mentioned. And I think, as Vlad mentioned, what we could have done better was, as we had that full offer down, that was the best opportunity to then speak about those interdependencies between the terms, to negotiate them in tandem as levers. And then one more point with regards to the stock options, we thought that our initial strategy was to really hammer in on that idea of how the employees are broken down, and we thought that understanding that would really best align the interests between FoodieLove and PlatFire, such that FoodieLove is really rewarding those employees that have actually had a long tenure at the company, that have been there since it was small. At the same time, incentivizing those newer employees to stay at the company. So it was unfortunate that we didn't have more information with regards to that, and because of that, we weren't willing to concede on an arbitrary percentage at the time, and I think we were right in terms of leaving that open for future negotiation.
All right, that's a wrap on post-negotiations. All right, we're going to proceed with some feedback from our judges before we announce and hand out some hardware to all of our finalists, who should be very proud for making it this far. Round of applause for our finalists before we get to feedback. Judges, some words of positive and constructive feedback for each team. We've got about 6 minutes, so however you want to divide that up. You'll also have a chance to speak with the finalists after the tournament, of course. Thanks again.
I'm happy to go first. My name's Clint Waasted. I am the head coach for the ADR team here. And you heard my voice in training. I don't remember if my camera was on or not. So I want to say good job to everybody. This is unreasonably small amount of time to do a lot of different stuff, and so we acknowledge all of those things. I'm going to start off by, because I know my colleagues here will talk a lot more about the substance and the numbers and what's more realistic, I'm going to focus just on negotiation because that's the part that's most important to me. So to do what I would want to do in 10 minutes in 1 minute, I would say, everybody did a great job. Everybody was massively professional, and so it always makes these things a little bit difficult. So the thing that I like to focus on is what will make you better at negotiating, right? Doing a better job as negotiators. And I think the pivot point for you, or the place for everyone to improve, and this probably goes for the entire room, honestly, is to shift your focus a little bit from conversation management to actually thinking about making offers and proposals that are persuading the other side to do some of the things that you want to do. And so I think we were really professional about getting numbers out there in a meaningful way, getting a framework that allowed us to get to an end point. But a lot of how that back and forth was dictated in the end point was, and I wrote down every quote that I could, we'd like to propose X, right? And then I have, as an initial standpoint, we'd like X. We were hoping for X, right? And then a lot of times people were in their counteroffers. We were looking for something closer to X, right? So what we were doing is really verifying whether the thing that we happened to want happened to work with the other side and their numbers, and we managed a process that kind of got us there. So to level up, I think when you think about some of the reasons you gave, sometimes people would ask why. Some of the reasons that you gave about, well, here's what we were hoping for, here's what concerns us, here's what we're looking for. We want to build that kind of thinking and those kinds of answers into the time when we're making our offers, so that we can start to figure out where are the actual soft spots of the problem, right? Were there places we could have gone up in a certain category while going down in a different category to see if we could get better outcomes or better results, and really push on those kinds of things. Now, can you do that in 40 minutes? I'm not necessarily sure, but I do think the framework that we had was a lot less thinking about how can I be strategic in terms of the words that I'm saying or the things I'm putting on the table, and a lot more about, am I just going to manage these numbers towards the middle in an evenly approach, right? And so if you go back and watch the tape, I may actually even send an email with these notes because they're very specific. But if you go back and look at the tape of this, I think it will be somewhere maybe, you'll notice some of that too. So that's what I would look at is you've got the management part down. Now let's focus on how can we be strategic to start to get to some of the soft spots in the problem. I'm done.
Thank you. First of all, you guys both did a great job. I'm so impressed. 1L's doing this amazing work. I'm really, really happy for you both. You guys, I can tell why you're both here at the end of the day. I like to keep it pretty short and sweet with my commentary, at least right for now. Both of you did a great job projecting, talking clearly, very, very organized. Very impressed with that. I appreciate that a lot. Good job. You two did a great job with your opening offers. The number one rule of negotiation is start at the edge of reasonableness. And every single one of your positions was at the edge of reasonableness. And I was like, good job. That's how you start negotiation. Way to go on that. Really, again, both sides, I'll have some constructive criticism later, but both sides, well done.
I thought you guys did a great job as well. I do want to give some constructive feedback. I thought, first of all, I thought you guys did a fantastic job in terms of driving the conversation at the outset. I know how these competitions go, and there's always the race to the whiteboard. That doesn't give you full credit, but I do think that you did a good job of just on the voiceover, doing a great job in that respect. I will say, I think that, and this goes for both sides, being comfortable with silence, being comfortable with putting out an offer, and then stopping instead of saying something like, that's our initial sort of position, or, I actually wrote down a number of things, but what I would say is that it sort of struck me as you were sort of saying, but not really, so feel free to come back. And we all know that you got to meet in the middle, but I think from a strategy perspective, I think you'd be better off in that respect. I thought you guys did a great job of asking open-ended questions. Whenever they were asking for something more from you, you said, tell me a little bit more about that. And I thought that was very, very helpful. You guys did a lot of that as well. And I thought it was interesting, at one point, there was a little bit of tension between you two, where you had said that, that they're dominating the security market. And I thought that was very interesting, and it was somewhat of a red herring fact in here. And then you took exception to that and said, don't catastrophize or something to that. That was interesting, query whether sort of how well that served the client interest at the moment. But I think you guys did a great job of bringing it back. So anyway, those are my comments.
Not too much more to add. I thought both teams worked very well with each other, across from each other. The way you thought about packaging the terms and how they fit together, the termination with the go shop, and taking your time, right? Not rushing certain terms that you just didn't feel like you could resolve. It was great to see the way that you both, on both sides, were wanting to understand what the end goal is, what the objective is, and try to solve for it that way. I'd say don't be afraid to be honest about certain things. Like, for example, why a termination fee is so high, because I want you to feel some pain if you walk away. Like, it's being candid and honest about, yeah, I want you to feel the pain, is an honest one. The matching rights, I think if there's one point that I kind of harped on, it's the matching rights, where I'd rather have a 90-day with matching rights than a 30-day without matching rights. That does kind of cool some of the potential interloper bids that could come in if they know at the end of the day you always could come back and beat that offer. It kind of deters folks from coming in. So just one more substantive point, but both sides did very well. I'm nitpicking when it comes to that. I thought, if you had like 10 more minutes, I could only imagine that the negotiation would have been even better. But it always comes together at the end. That's how it is in real deals that we do. So it's 10 extra minutes probably would have ended up the same way if you had it.
They would have needed another whiteboard, though.
It's true, yeah. So, thank you.
To all of our judges. I also want to recognize, in case any of you were wondering, all of our judges are incredibly well credentialed, but we are lucky to have the founder of this competition, Joseph Halloum, who was just speaking, joining us as a final round judge today. Round of applause for all of our final round judges as well. All right. right, so without further ado, I have some hardware, AKA trophies, that I need to hand out to all of these 4 wonderful competitors who worked so hard to get here and deserve to be recognized. But ultimately, we are here also to declare a winner, a champion of this year's tournament. So without further ado, the winning team, according to, by the way, if we have competitors who were in the competition in the preliminary rounds, we used the same evaluation rubric for these teams that was used in preliminary rounds as well. The winning team of this year's Halloum negotiation competition is FoodieLove, Olivia, and Eloise. Congratulations. Thank you all so much for being here. Feel free to come up, congratulate our finalists, grab some chips and guac on your way out the door. Sorry that arrived late from Chipotle today. Have a great rest of your day. Enjoy spring break. We'll see you next year for competitions.